Thank you again for tuning into today's webinar. And now to introduce our experts. James Shoemaker is Executive Vice President of Business Development for Castle Group. James is a real estate veteran with over 25 years of operational and business development leadership. Prior to joining Castle Group, James served in executive positions for national and global real estate companies, building strategic alliances and partnerships for tactical growth and results. James is going on his 8th year with Castle. Prior to his current role, he was a former regional president for Castle. Noel Hicks is shareholder in the Property Owners Association Law Section of RMWBH. Noel assists single-family residential, townhome, condominium, and commercial associations with various aspects of Property Owners Association law, including the collection of delinquent assessments, complex deed restriction enforcement issues, developing and interpreting governing documents, and drafting and reviewing contracts. In addition, she works with her association clients on various issues, such as ensuring compliance with state and federal laws, attending administrative hearings, 209 hearings, and board meetings. In addition to her work with clients as their attorney, she also works with clients to ensure they are educated in the rules and statutes governing property owners associations. Noel is an active participant in RMWBH's growing POA education program. Noel educates attorneys, community managers, and board members through various webinars, board training seminars, and more. She also speaks statewide through the State Bar of Texas and local CAI chapters and at national CAI conferences. And with that, I will turn it over to James.
Thank you, Megan. Really looking forward to being here today. So just a brief little plug on Castle Group, and we're going to get to the real good stuff with Noel. So Castle Group, 40 years of community association management. We're 2,500 teammates strong with over 500 associations, and we represent over 300,000 homeowners that we manage in a variety of products, condominiums, villas, townhomes, and large associations. Again, really looking forward to working with Noel and RMWBH and having a riveting discussion on all things related to the legislation and the restrictions and the CC&Rs and all that fun stuff. So Noel, thanks for giving your time today, and looking forward to listening in on.
Yeah, thank you so much, James. I appreciate that. I hope it'll be riveting. We'll see how riveting it is. But okay, I want to thank you guys so much for having me. I'm going to go ahead and get my slides here on the screen so that we can get started today. Thank you guys so much for having me. I'm really excited to be here. I'm actually really looking forward to the relationship between Castle Group and Roberts Markel. I know that it's going to be something that's so great. I'm really looking forward to it. So can you guys see my slides okay, James?
Perfect.
Excellent. Well, let's go ahead and get started. Today, I'm going to talk a little bit about the ever-evolving deed restriction process. And the reason why we say that it's ever-evolving is because the laws are always changing. Things are always coming up. And you would think that these would be things that we could just like automatically know, or laws that we, automatically can interpret. But sometimes we come across some things that are a little wonky, a little bit hard to understand. And so it's important for us to kind of keep up with these laws so that we are kind of staying at the forefront of the industry, right? So I am a lawyer, so I do have to give a little disclaimer. The information that I'm going to give you today is the law as it is today, September 27, 2023. I am not presenting this for legal advice. It is for educational purposes only. If there are any questions about any of the topics that we go over, please feel free to reach out to me or your legal counsel of choice. Hopefully I am your legal counsel of choice, but definitely make sure if you have any questions to reach out and we can get those answered for you. So of course, today we're talking about deed restriction violations, and we're going to go over some fundamental basics about deed restrictions. We'll talk a little bit about dedicatory instruments, how to create and enforce governing documents, some common violations for you to look out for, the self-help provisions that you might have seen, and then also we'll talk about a couple of the statutory requirements we could actually do an entire presentation on statutory requirements. So I will just mention a few here for us today, for us to keep in mind. And then sometime in the future, I'll come back and talk to you about all of the statutory requirements for deed restriction violations. But let's get started. So deed restrictions or dedicatory instruments are really a regulation of land use, right? A lot of times, though, people think that no one should be able to tell a person what they can do with their property. And that's really the case here in Texas. I know that in Florida, it's pretty much the same way. I know that there are a lot of community associations, condominium associations. I was just in Hollywood, Florida last week, and I could see condos everywhere. So I know that there's a lot of community associations there, but I do know that people have that deeply ingrained belief that no one should be able to tell them what to do with their property, right? But, you know, part of the reason why we have community associations is because people are very, very keen on making sure that they keep their property values high. And in order to do that, we do have to have some sort of regulation somewhere, right? We do have to be able to have us and our neighbors have some sort of restrictions on what they are permitted or prohibited to do. So there is this inherent conflict between a person wanting to do whatever they want to with their property, but also keeping their property value high. And honestly, you know, we go back to that initial slide that I showed, these pictures there. If you're living next to something that looks like that, then your property values are declining at a rapid rate. So we want to make sure that that's not happening, right? So because of this, we have the birth of restrictive covenants and the community association. And that the purpose of that is just kind of to administer this plan or these restrictions that we're going to be talking about today. So there is case law that surrounds this, obviously, with dedicatory instruments. The case is Curley versus Walker. It's one of the fundamental cases of deed restrictions and dedicatory instruments. It was decided back in 1922. So you see how long ago this happened and how deeply ingrained this is in our society. But essentially that case basically said that an owner burdens his own land with restrictions because of the fact that a like burden will be imposed on his neighbor's lot, and that it's going to be beneficial for both lots. So of course, a person who is in a deed restricted community wouldn't want any sort of deed restrictions to be imposed only on his lot, right? They should be imposed on all of the lots, that person's and their neighbors, for it to actually be beneficial to the entire community. So that's kind of the idea behind deed restrictions and the reason why we have them. So now deed restrictions are definitely governed by the Texas Property Code here in Texas. But there is a definition for what a dedicatory instrument is. You'll hear me talk about that a lot. Dedicatory instrument can kind of be a synonym for that is a governing document. Some sorts of varieties of dedicatory instruments are controlling documents, right? Like the DCCRs, or the declarations, covenants, and conditions, bylaws, and things of that nature, which we'll get into a little bit on the next slide. But the definition that our Texas Property Code actually has for a dedicatory instrument is a governing instrument covering the establishment, maintenance, and operation of a residential subdivision. And we certainly know that that's true in the DCCRs. You see that it covers the maintenance and the operation of a subdivision. Of course, the bylaws provide the governance and how the body or the board of directors should behave as far as running the association. So you'll find that in the dedicatory instruments, right? And so here are some examples. Of course, there is a governance of community associations, and some of the documents that you're probably familiar with are like a plat or certificate of formation. And I kind of have these listed here in a hierarchy, so to speak. So obviously the plat is one of the most important documents because it sets out a map of the community, the streets, the easements, if there are any reserves or anything like that. All of that information will be found in the plat. Whether or not the streets will be private or publicly held, if there are utility easements, that's there. Sometimes there are certain setback lines. That information will be found on the plat as well. So the plat is the most important document, and it certainly covers a lot of the restrictions for communities. Of course, that gets a little bit more detailed in the DCCRs, but the plat really sets forth whether or not this is going to be a restricted community. Then in order to actually create a community association, we have the articles of incorporation or certificate of formation. The restrictions, as we've talked about a little bit, set forth like use restrictions, maintenance obligations, assessments, things of that nature. Bylaws are the governing documents for the board of directors. It sets forth things like how meetings should be held, notice requirements, the different positions on the board, things of that nature. Now, a lot of times too, you'll see that there are only a DCCR and bylaws. And on other occasions, you'll see that there might also be a guideline, a architectural or builder guideline that kind of lays out what sort of material should be used when people are making improvements on their property. And usually you'll see the process that to submit an application to the Architectural Control Committee to actually get approval for those improvements, right? And then a lot of times too, you'll see certain rules and regulations, maybe even some policies, other things that kind of govern how the association should be run. And it won't necessarily, so of course the DCCRs are the end all be all document. The guidelines, regulations, or policies that I'm talking about will expound on certain things that you might find in the DCCRs, but it won't expand on it. Here in Texas, we have some case law that was not too long ago decided where it basically said, and this actually had to do with short-term leasing, where it basically said that the declaration itself needs to be pretty specific about certain restrictions. And if it's not, a policy or guidelines can't expand on those restrictions. Really, the way to change something or make something more specific would be to amend the restrictions. So we got to kind of keep that in mind. Restrictions are what they are, and policies and things of that nature could expound on them. Also, a lot of times when you see policies, it is because there has been some change in the law, and it might be a little bit too difficult or too prohibitive to amend a restriction to include that. But we know that the law actually supersedes what's in the restrictions. So we'll create a policy to make sure that the association is completely up to date with all of the changes that go on with the legislature. So that's really a good place for policies to fit in. So in addition to this sort of governance, right, the dedicatory instruments, community associations are also governed by several other different entities of law or bodies of law. Of course, there are municipal ordinances, there are state statutes. Here in Texas, we deal with the Texas Property Code, obviously. We also deal with the Business Organizations Code because that is the code that governs nonprofit corporations, which community associations are generally formed as a nonprofit corporation. And then we also look at the Texas Finance Code. And part of the reason why we look at the Finance Code is because oftentimes the restrictions will authorize an association to collect assessments. And if there is a delinquency on that assessment, to charge interest. Well, we need to know what interest is the appropriate amount of interest, right? Sometimes the governing document says 10%. Sometimes it says the highest amount that's allowed to be collected by law. And so in order for us to understand what that amount is, we look to the Texas Finance Code to figure that out. And right now that's sitting right about 10% for interest here in Texas. So those are state statutes. With federal statutes, we also have to look at the Fair Debt Collection Practices Act when we're dealing with collections, the Telecommunications Act, the ADA, and the Fair Housing Act. Those are things that come into play a lot when we're dealing with deed restriction enforcement as well. All right, so the declaration, which I've talked about a little bit already, is a document that has to be a living, breathing document. And the reason why we say that is because it needs to be capable of change, right? There are things that come up that we might have to go into the governing documents and adjust them. For example, the other day I was dealing with a community. There is a master community, so to speak, and then like a sub-community, right? The sub-community authorizes, their declaration authorizes the collection of assessments. A regular assessment, that's kind of like the assessment that goes to the master of the community, and then a subdivision assessment. But this sub also has a pool that needs to be maintained, right? And this sub is kind of behind on their payments to the master. But in the declaration for the sub, there is no provision for a special assessment. And that would actually be like the most prudent way for the association to be able to catch up with the amount of money that they need to continue to maintain the pool. But there is no provision for that. So my recommendation to them is, while they need to try to increase their normal assessments, they should also look into amending the declaration to create a provision for a special assessment. As you know, a special assessment can be a one-time assessment that is created or imposed on owners to be able to pay for certain things like maintaining a pool. And if they can't do that, then they might have to shut down the pool. But so that's the reason why a declaration needs to be a living document that's capable of amendment or change. And it has to really change with the times because, as you know, every 2 years, especially here in Texas, every 2 years we have a legislative session. And in every legislative session, I've been in this industry since 2017. Every legislation, we have had some dramatic change in the way that we do things, right? In the way that community associations are governed, some change in the property code that's like drastically changing the way that we do things. So we have to be able to change with the times. And if you consider, a lot of these restrictions were filed, in the 20s and 1920s, along with that case law that I talked about earlier. So things have changed since then. It's 2023. Some of these restrictions, you'll look and you'll see that they only allow a certain type of people to live in the community, or they only, they don't allow businesses and that kind of thing. And while most of us don't want to have like a full, a full out business in our community, a lot of us are still working from home. And so sometimes there are, restrictions in our documents that say that no business whatsoever is allowed. And so sometimes, technically by us operating our business from home or working from home, we're violating our restrictions and we don't even really realize it. So that's why things kind of have to change with the times. And also our documents really need to change as technology changes. During the pandemic, everyone kind of switched over from doing things in person to doing things by Zoom. And so because of that, currently there are no real provisions in a governing document or in the bylaws that allow for a community to meet, by Zoom or electronically or anything like that. And so we had to kind of rely on other laws to allow for meetings to be held by Zoom or something like that. But we also want to make sure that our documents reflect that, because now that's how things are being done. A lot of things are being done by Zoom, by text or whatever. So we got to make sure that our documents stay up with the times, right? So that's why it's important for our governing documents, especially our restrictions, to be a living document.
Noelle,
Now,
if I could just ask you, I'm sorry,
Yeah, sure.
you made me think about the technology piece. Is an example of that is the ability to have electronic voting or opting in? Like that's another technology change that they didn't have with antiquated docs?
Absolutely. So, because that was such a big thing in 2020, right? We're trying to figure out what to do. We had to go look to other provisions, not the property code, but like the business organizations code or something like that. And in the business organizations code, it does say that a nonprofit organization is allowed to have electronic meetings, right? So we had to use that to say, okay, well, because the business organization code actually governs nonprofits, not property owners associations specifically, we're allowed to go ahead and have electronic meetings. But that really took some like workaround, right? Some research to try to figure out how to do that. So that's why it's important for us to kind of stay up to date with all of these different laws and stuff so that we know what we can use in order to help our communities be able to continue to operate.
Great,
right?
Thank you.
Yeah, so, it's really important, I mentioned, to have these restrictive covenants in place to protect and preserve property values. I don't know about in Florida, but we don't have zoning here in Texas. And so if we did not have restrictive covenants, there could be a club next to someone's home or, something like that there's no remedy for that, right? There's no way to prevent that because we don't have zoning. So restrictive covenants are very important. It's vital to have that in places like Texas where there is no zoning.
Yeah.
All right, so enforcement by community associations, of course, we are permitted to enforce things by the Texas Property Code. And then also we have our restrictions, which a lot of times the restrictions kind of take a deeper dive into what sort of things can be enforced than the property code would. And then there are some times where the restrictions say something that the property code says something different. Of course, we would look to the property code because that is the overarching superseding document that we go by. But, we have to just make sure. So a lot of times if I'm asked a question by a community, I'm going to look at their restrictions, but because I have, that knowledge of the property code, I'm going to say, wait a second, property code says something different. So we're going to have to go with the code says here, right? And I'll talk about a couple examples of that in just a few minutes. So of course, restrictive covenants, they allow give certain permissions on property, and there are certain prohibitions. But essentially they give the community association, and they also give individuals the right to enforce the restrictions, right? This is news to some people, but most of the time restrictions give individual homeowners the authority to enforce. Now, there are some things that they won't be able to enforce, right? For example, the association is the only entity that has the ability to collect assessments. So a homeowner would not be able to enforce the restrictions in that way. But a homeowner can enforce use restrictions, right? So that means that if a neighbor, finds some sort of violation of the property code, they're going to have to go through all of the same steps that the community association would to enforce the restrictions. But ultimately, if they felt strongly enough about it, they could go file a lawsuit against this homeowner for violating the restrictions. We don't see that done very often because a lot of people don't know that they have the ability to do that, or they don't have the money or even, the bandwidth to do it, but the right is still there. All right, so here are a couple of examples of certain restrictive covenants. Here we have this white picket fence that's falling down again. So of course, this would likely be a violation of restrictions anywhere, and that would likely fall under the architectural review restrictions. But of course, most of the time our restrictions prohibit non-residential uses of property. When we're talking about non-residential uses, that's when business use comes in. A lot of times, what also falls underneath this category is short-term rentals. So Airbnbs or VRBOs, and I'm sure that is a huge problem in Florida as well as it is here. I don't know if you guys have heard, but New York has essentially made it impossible for people to use Airbnb or to have Airbnbs now. A lot of people are so scared that that's going to happen here in Texas as well. But because I have a couple of Airbnbs, guys, don't tell anyone. They're not in restricted communities, of course, but I would hate it if, that aspect was shut down. But I mean, we understand the reason why they've done that, right? Another example too is for prohibiting single or multifamily occupancy. So in addition to non-residential uses, the restrictions will also say something like single family residential use only. So that means that it can't be like a duplex kind of situation. You can't have several families living in one property, just like living out of one room or something like that. That also kind of can prohibit Airbnbs or short-term rentals if a person is just like renting it out per room in their house. There might also be requirements to improve things or things to be maintained. So like this fence would be something that had to be maintained. The yard is something that has to be maintained. For example, I'm full of stories, guys. So I have a community here in Texas or here in Houston. It's actually a little bit farther out, about an hour away from here. And there is a property owner who I filed a lawsuit on him. Actually, I think this lawsuit might have been filed before I even got to this firm. So this was back in 2017. And it is largely a maintenance lawsuit, right? Deed restriction violations. And this guy has an actual jungle on his yard. And because the restrictions are kind of vague as to what is required for the yard, so it doesn't say that there must be grass. It doesn't give like a height for the shrubs or anything. There are no specifications. It just says it needs to be well maintained and in a sanitary condition. Then this homeowner has been able to skirt these restrictions and just kind of float by in this lawsuit for a very long time. And also because the judge kind of refuses to try the case because she has more important things on her docket, I'm sure. But in the meantime, all of his neighbors are suffering because there are rodents and snakes and, all these sorts of things because it's a big jungle mess. This is another reason why our restrictions need to be living documents, because if we see situations like this, and of course, when we're writing our documents, we don't always think that these kinds of situations will come up. But if we see a situation like this and we say, oh, we need to make sure that we amend our restrictions to prevent situations like this from happening in the future, that's a lot of times when we see, the need for updates to our restrictions. Mm-hmm. Of course, there's also the architectural review aspect, right? We need to make sure that there's some harmony of exterior design, harmony of colors. That kind of thing will go into the guidelines too, right? So if there is a ACC application, a person wants to paint the outside of their residence, 9 times out of 10, they're not going to be able to paint it purple, right? but the guidelines will say neutral tones, or, you know, give a list of things of paint colors or something like that, so that we can have some harmony of design and color. And that also goes back to making sure that we're preserving the property value, right? Because who wants to try to sell or buy a house that's next door to a purple house with a pink door, right? That's kind of crazy.
Mhm.
So that's why these are important. All right, so the way that we enforce, or the authority that we get to enforce deed restrictions, community associations themselves, comes from the property code. It's in 202.004 of the Texas Property Code, and it essentially is giving the association the authority to file lawsuits to enforce restrictions if necessary. And of course, there's a procedure that you go to, or what we call conditions precedent, that you have to make sure that you comply with before you actually get to the stage of litigation. But the association does have the authority to do this. So not only does the association have the authority to file a lawsuit, it also has the authority to recover its attorney's fees. That's also found in the Texas Property Code. So a person that prevails in a suit to enforce restrictive covenants is entitled to reasonable attorney's fees. Reasonable attorney's fees are determined by a court, but we do still have this authority where we can recover attorney's fees. Now, there are also certain conditions precedent to this too. Section 209.008 requires that the association send out notice to homeowners. These are what we call 209 letters, in order for them to actually be able to recover their attorney's fees. But we do have this mechanism in the property code that allows for us to do that, and that's great. Because if you can imagine, a lot of times an association will spend a lot of money trying to file a lawsuit to enforce restrictive covenants because a homeowner has just dug their heels in so badly that they don't want to comply. Or, you know, maybe the timing of it wasn't great. And sometimes we, you know, caught someone in the middle of building an outdoor kitchen or something like that, and it's substantially completed. But we're still going to have to, you know, make sure that we enforce the restrictions, but we have to do it. We have to do it uniformly as well. So we are going to need a way to recover our attorney's fees, because ultimately that money is the association's money as part of the assessments that homeowners pay. All right, so I mentioned earlier that not only can the association or the board itself enforce restrictions, but also owners can do that. They have the right to do that in the restrictions. It usually says it can be enforced by the association or homeowner. Of course, that is exempted, or that excludes the lien rights I talked about earlier, any rights regarding assessments retained by the association. So homeowners don't have those lien rights, so they cannot enforce that aspect, but use restrictions they certainly can. And the way that we kind of figure out whether or not this would be something that the association should enforce, or maybe a homeowner should enforce, is this a community nuisance, or is this a private nuisance? Is it a neighbor to neighbor dispute? Is it a property line dispute, something that's happening on the boundary of the properties between two neighbors? Then that's something that's a private nuisance and should likely be handled by homeowners. But if it's something that's affecting the entire community, then of course the association has the authority to step in and enforce the restrictions that way. Now, there is a presumption of reasonableness, right? The association does have discretionary authority, and the way that the association uses or exercises this discretionary authority is presumed reasonable by a court, unless, of course, it was done by arbitrary, capricious, or discriminatory ways. Now, those words are big, huge legalese terms that I don't even always know what they mean, but on the next slide, we'll talk about their definitions. So arbitrary means that they failed to exercise honest judgment. So if you think about just like somebody doing something arbitrarily, it means the same thing. Capricious is fickle, unchanged, or changeable, or unsteady. It also can include the word arbitrary, but this is also, these are essentially ways that a person can defend a lawsuit for enforcement of restrictive covenants. If a homeowner can prove that the association acted in an arbitrary, capricious, or discriminatory manner, then that is a viable defense to an enforcement lawsuit. What's interesting is there are other ways, which I'll talk about in just a second, to defend a lawsuit, but this arbitrary, capricious, and discriminatory comes up quite a lot. And earlier I mentioned in the context of short-term rental related lawsuits, if a restriction is not pretty specific about prohibiting short-term leasing or having some sort of restrictions surrounding or limitations surrounding short-term leasing, then it could be considered arbitrary, capricious, or discriminatory if an association tries to prohibit a short-term rental in a person's property. There's a lot of case law on this. There is a cluster of cases that are before the Texas Supreme Court right now, trying to decide this very thing that our firm has been heavily involved in. So we are kind of waiting on that for right now, but it's important to understand that, you know, we look at those restrictions and we're reading them, and if they're kind of vague and we're not sure that whether or not they can be enforced based on the set of circumstances that's happening, we got to make sure that they're not arbitrary, capricious, or discriminatorily enforced, right? A couple of other defenses that may come up in this context are, one of the biggest ones that I see is statute of limitations. So in Texas, there's a 4-year statute of limitations to enforce a deed restriction violation. That's also true for collections. But essentially, if a person's fence is falling down and it's been falling down for 4.5 years and we're just now trying to enforce that, we cannot file a lawsuit on that. That is something that is barred from suit by the statute of limitations. But the association does have some sort of, you know, way to get around that, because there's this thing called the discovery rule. So even if the fence has been falling down for 4 years, but the association didn't learn about it until yesterday, then technically that statute of limitations doesn't start running until yesterday, or that's an argument that can be made to the court. There's also the laches, or like an equitable defense. And this is basically recovery. It's barring recovery by the association, who's the plaintiff in that situation, because they waited such a long time to seek relief or to file the lawsuit. It kind of goes hand in hand with the statute of limitations, but it's the equitable version of statute of limitations. And then there's also waiver and abandonment, and we'll talk about waiver. Waiver is essentially that the association has failed to enforce restrictions, and so they waived the restriction, or they abandoned the restriction, so they waived enforcement of it, right? And so basically, you know, essentially what it is, the theory is that there's no longer a possibility to secure any substantial degree of benefits through the covenants, because the association has completely failed or abandoned enforcement of that restrictive covenant. So this is a legal defense. It's difficult to prove. There are there are statistics involved, because you would have to show that there's, I think it's a 32 or 39% of those types of restrictions still present in the community. And so it would show that the association has waived their right to enforce. So this is difficult to actually bring up as a defense, but it's out there, right? And you can either waive a provision or several provisions, or you can waive the entire set of restrictions, but really you have to look at the reasonableness test. And a lot of things can be determined by a reasonableness test, right? Like whether a reasonable person could conclude that the restrictions have been abandoned. So that means if you are driving through a community and you're looking around and you notice that more than, you know, a couple houses have fences falling down, then you might think to yourself, well, the association has likely waived the enforcement of the provision to maintain a fence, because there are so many fences, the nature and severity of that restriction is high. And so that could lead to a waiver defense. All right, so let's talk about a couple of common violations. We talked about a couple of common things that can be included in restrictions, but what are some common violations that we see? I mentioned to you the story about the landscaping violation. That is one that we see a lot. A person has failed to put in the right type of trees, or they're not cutting their yard the way that they're supposed to, or in enough time. You know, generally a person should cut their yard once a week during the summertime and maybe every 2 weeks during the winter. So that kind of thing is a common violation. Exterior maintenance. You can see that there's like kind of siding on the blue house right there. Sometimes people like let that siding fall off, or they have allowed grime or mildew or something like that to grow on the side of their house and they haven't cleaned it off. So that's a common violation. People building things without architectural control committee approval. That's a huge one. That's something that we often have to file a lawsuit on, because a lot of people, maybe it's not that they don't respect the restrictions, but they certainly think that they can just kind of go build whatever they want to, especially if it's in their backyard or something like that. But a lot of times restrictions say, you know, anywhere on the lot, you have to seek approval for that. So a lot of lawsuits get filed for that, right? Parking violations, trash can violations, and then one of the other ones that we see a lot is nuisance annoyance. Now, I will say that the nuisance of annoyance provision of the restrictions is kind of a catch-all provision, and it's not the strongest one that we can use in court, because it's vague, right? A nuisance can be anything. So sometimes it's important, like if the association wants to enforce a restriction, that we actually have a provision that can like kind of stand behind it, because just using the nuisance provision is not the strongest legal theory to use when we're trying to file a lawsuit.
Noelle, it's interesting, violations are an issue at all of our associations, and, specifically our associations we manage in Texas. A lot of times as a management company, we really have improvement on adherence and adoption by just better communication. Giving them an upfront communiques that, guess what, next month, we're going to be sweeping the neighborhood looking for landscaping enhancements, beautifications. Here's a reminder of what your documents state. And, whatever it is, we found a better outcome when you give communication, tell them we're coming, as opposed to they don't know and all of a sudden they get that nasty letter. So we found that just by having consistent and more useful communiques, that it actually helps this whole issue as a whole,
Absolutely. So James, I literally preach communication all the time. I've done all sorts of these kinds of presentations and other topics and all that. And it is important for the community, the board, and its representatives to have transparent, open communication with the community, right?
Yeah.
And it is important because a lot of times, think about it, when people buy houses, they're not always reading all of the documents that come along with those, the closing documents or whatever.
That's right.
And that includes the restrictions. And while that's not a defense, to the deed restriction violation, it's always helpful to have those reminders.
Yeah.
To just kind of help things along a little bit, because you're right. Once they get those nasty letters that say, hey, you need to do this or you're going to get a fine or whatever the case may be, that's going to make them feel a certain type of way, right? Because they're going to say, why didn't the association just call me? Well, you don't have the duty to do that, right? Your responsibility is not to call people, but if at a board meeting or at a town hall meeting or something like that, you can remind people, we're going to do those sweeps for violations, or you guys are responsible for making sure your trash cans are in or your yard is cut. That's always very helpful, and it can keep people out of the lawyer's office. And it can also save the association a lot of money ultimately, because you don't have to pay for the attorney's fees in order for us to enforce these things.
Right.
That's a very good point you just made. Okay, so sometimes restrictions do have what we call self-help provision. And sometimes you guys might refer to these as like a force mo, right? Not all the time, but if there is a provision in the documents for self-help, then there is likely notice requirements or something of that nature. So basically what this means is if a person has allowed their yard to get, 10 feet tall, the grass is 10 feet tall, and they are ignoring the letters and they are ignoring the reminders and all that kind of stuff, then the association potentially has the authority to go onto the lot and mow the yard. Because obviously one of the main purposes of the board or the association is to preserve the property value. And so if it can go onto a person's yard and do that, mow the yard, whatever needs to be done, then that helps the neighbors around it, right? Now, a lot of times the lawn maintenance is not the only issue that could be outstanding on a person's property. We don't necessarily like to advise any other maintenance other than lawn maintenance, because we don't want the association to expose itself to liability for like trespassing or, touching someone's property or whatever. But, that's a conversation to be had with the attorney to just make the best decision, right? But so the notice requirements are generally like after you've sent some other sort of notice, right? You can send a 10-day letter to the homeowner and say, listen, we're going to give you an additional 10 days. We've sent you notice before. We're going to give you an additional 10 days to correct this violation, mow the yard, whatever needs to be done. If you don't do it, the association is going to send its landscaper onto your property to mow your yard. Now, the person could do it within those 10 days and there'd be no problem. But if they don't, then you can certainly send someone out there, and then those fees that the association incurs for, correcting that violation or performing that maintenance can be added to the homeowner's account. sometimes the declaration allows for those amounts to be collected as an assessment as well. Now, you need to be careful in this sort of situation, because people, if the person is home, then they may come out and tell the landscaper to get off their property. Or, you know, here in Texas, we're a stand your ground state. So we don't want people to come out of their property with shotguns, you know, chasing the landscaper off the yard.
Yeah.
They have the authority to do that, right? It's their property. So I would make sure that everyone's exercising caution when we do this, but there is that authority sometimes in the restrictions. And before you do this, you need to make sure that you do have the authority to do it, because if it's not in the restrictions, then you don't have the authority to do it. So we just need to make sure, even if you need to consult with your attorney, to make sure you have that authority. And even if you need assistance with like crafting the letter that should be sent, consult the attorney for that. And then also just make sure, you know, there's a difference between secured and unsecured. So I mentioned that those costs might be able to be collected the same way as an assessment. That's what secured costs are. It may not say that in the restrictions. And so then that would be an unsecured cost. And so it would not be secured by the association's lien. But either way, those costs should be added back to the homeowner's account, because ultimately they're responsible for it. Now, there are two different types of violations. The property code in section 209.06 talks about an uncurable violation versus a curable violation. We'll talk about these uncurable violations first. An uncurable violation is just something that happens one time, generally. It's not a continuous action. It's not something that can really be like caught in the act. So examples of that are like on the 4th of July, when they go out and shoot fireworks in the middle of the street, that's an uncurable violation. Or if someone has a party, uncurable violation. If they're not having that party like every weekend, this is an uncurable violation. A garage sale or something like that. I will tell you a funny story. I have a community that they have restrictions that disallow garage sales, right? And of course, they don't always know when a garage sale is going to pop up. It's not like people advertise that all the time, right? Sometimes they just like stick a sign in their front yard on a Saturday morning, and then there's a garage sale. Well, the community was calling me on a Saturday morning to stop this garage sale. Now, there's not a lot I can do personally myself on a Saturday morning to stop a garage sale, because it's just not safe for the attorney to come out on a Saturday morning and run up to a person's house and say, stop your garage sale, right? But in a situation like this, if there is a garage sale happening that is prohibited by the restrictions, then the best thing to do would be to call the cops, right? And try to get the garage sale shut down. But that's the kind of uncurable violation that I'm talking about. Now, we still, if the association is alerted of this uncurable violation, we still want to send a 209 letter. And I've talked about certain statutory requirements. Now, a 209 letter has to generally give the homeowner a certain cure period, right? 30 days to cure a violation. That's not possible when there's an uncurable violation, so that's not required. There are other things that go along with that too, right? The homeowner has the opportunity to request a hearing within that 30-day time period. And if the association has fining authority, you have to wait 30 days in order to like put that fine on their account. But if it's an uncurable violation, then you're not having to wait those 30 days. So you can just automatically fine a homeowner if the association has fining authority. That's different though with curable violations. So examples of that are parking violations, maintenance violations, things that happen that can be documented, that you can send a letter to someone and give them that 30 days time period to cure, fine them if you have fining authority, give them that opportunity to be heard by the board, that sort of thing. All of those things go into the 209 letter that you would send to that homeowner to let them know of this deed restriction violation. Interestingly, it's hard to document a dog barking. You know what I mean? You have to like, you know, put a recorder out there or something like that, but ongoing noise violations are curable violations. So if the neighbor has a dog that's barking every single night, it's keeping you up all night, stick your phone out there and record it so that there is some sort of proof that that's happening. Because ultimately, when I go to court to file this lawsuit and enforce this restriction, I have to be able to prove to a judge that the violation exists, right? It's difficult to just stand in front of a judge and say, Judge, well, they told me that the dog was barking every night, but you know, that's all I got. I need to be able to have something to prove to the court that this violation actually exists. So some sort of documentation of that sort of thing, ongoing noise violations, is really important. Documentation in general is important, but especially of noise violations, that's very important. Now, also, of course, I probably wouldn't be filing a lawsuit on a noise violation unless it was like a completely egregious situation. But again, documentation is really important. All right, so there are a couple of other statutory requirements. So earlier I talked about policies and how if there are changes in the legislature, the best way to document those are by policies, because naturally these changes in legislature are not something that we can easily add to the restrictions, because the restrictions generally, if you're going to amend them, it takes a 67% approval from the community, and that's difficult to achieve sometimes, especially in larger communities. So what we would do instead is to memorialize these new changes from the legislature. We memorialize those in policies that get filed in the real property records. Some of the things that we've seen change over the past several years are political signs and displays. Those are governed by the election code. And a lot of times we like to create a policy that's specific to that, because similar to these signs on the slide here, we don't want people to leave those up all year round. They need to only be there during the election cycle. And if I'm not mistaken, you could put them up 30 days before, and they need to be taken down 10 days after the election. So the election code actually provides those restrictions, and they apply to property owners associations. Religious displays, that's something that recently changed in 2021. So we created policies. It actually changed in 2012 and then changed again in 2021. So we created and then updated religious display policies to make sure that we have these in place for associations so that they can enforce them. And of course, they're enforceable because they're in the Texas Property Code, but it's always better to have that policy that applies specifically to your community. So you can point to that for a homeowner and say, hey, listen, these are the restrictions for us. These are our policies. This is what we have to go by. The security measures one is a big one. This one came about in 2021. And it left a lot more questions than it did answers. So for example, this policy or this change to the property code would allow for a person to put a perimeter fence around their entire yard, but it was unclear if that meant on the property line, on the setback line, what exactly or where exactly are we talking about? And then it also did not give a lot of specifications as far as how tall this fence could be, what materials it could be made out of, things of that nature. So this one has been very difficult for us. However, we did come up with, participated with TLAC, the Texas Legislative Action Committee, through CAI to help write another statute or a bill that would clean this up a little bit. It was vetoed in the earlier this year, but we are expecting, and I'll talk about this in just a second, we're expecting for this to be revisited here in October. So hopefully we can get a little bit of relief from this, because this one has been kind of crazy for all of us. And then also there's some new changes to the 209 hearing laws that just happened in 2023. And so essentially now, okay, a homeowner has the ability to request a 209 hearing, but how that hearing is held is changed up a little bit. So now the association has to provide the homeowner with a evidence packet of all the information that it's collected that's related to that violation, and provided to the homeowner at least 10 days before the hearing actually occurs, and a couple of other things too. But they're just things that need to be memorialized in a policy to help the association operate at its most optimal level, right? Now, there's some other new things too. So there was a change to the fine policy. Now, we've always recommended that the association have an enforcement and fining policy if they have fining authority in their governing documents. But now the new legislation from this year, and it only applies to associations that actually can levy fines, but the policy has to include general categories for which the association can fine. And that has to, we like to put it in a table essentially in the fining policy, the schedule that I'm talking about, so that it is very clear. And it also needs to include information on hearings that I talked about on the previous slide from section 209.07. And so also the fining policy, in addition to it having the schedule of fines for each category and violation, it also either has to be provided to homeowners by posting it on a website, or it has to be sent to homeowners annually by hand delivery, mail, or email. So these are the new requirements for our fining policies. Now, I mentioned the security measures policy. We are hoping that this October special session that has been called would have SB 1668 on the agenda. This is the one that's going to clear up some things in the security measures policy or the security measures law that I recently talked about. And if it gets passed, which we're really hoping that it does, it's going to require condos to have a publicly accessible website and post it on TREC the same way that single family communities do. It's going to define security measures a little bit better. And then it's also going to change the ACC committee eligibility requirements, because right now it's been very difficult for communities to find people to serve on the ACC when they cannot be board members as well. So they've made those two completely separate entities, and that just made things kind of difficult. All right, so in conclusion, of course, all of the rules and restrictions that we're talking about, they're going to vary from one association to the next. That's why it's important to just know them, understand them, and get your attorney's input on them where needed. We should make sure that every time we are enforcing a violation, it has to be equal for everyone so we can avoid those claims of arbitrary, capricious, or discriminatory enforcement. And then in the end, we just want to make sure that we're reasonable, apply that reasonableness test, because it's very important. We want to make sure that we're doing things in a uniform manner, right? So that we don't get lawsuits filed against us, but also we just want to be reasonable. So that is all that I have for you today. I know that I've left a little bit of time for question and answer.
Yes, thank you.
So James, do you have some
much.
questions for me? I'm going to stop sharing so we can.
Yeah, you could just keep it right there. That's actually.
Oh, okay. All right.
Thank you. That was really insightful, and we do have about 7 minutes left. We'll try to get some questions that came in. Well, and if we don't get to them all, we'll make sure that Megan can follow up with the individual person. But really, really well done, Noelle. It just shows that so much of this is about communication, as we talked about, but also there's some subjectivity to so much of this, right? So good documentation, good evidence to help cure the situation. But it's really interesting. So thank you for that.
Sure.
So I guess a few questions that come in. One of them is, if there is not a fine policy and the association does not have it written into the declaration, how do they then establish those fines?
We have to amend the declaration. And that's really the only way. So if the association does not have fining authority in its restrictions, it cannot assess fines. So we have to give it authority first by amending the declaration, and then we can come up with a fining policy that's appropriate for the community. Now, that's going to be difficult though, because that threshold for amendment is usually pretty high. It's usually at 67%. In a large community, that's difficult. But it's one of those things where you can take as much time as you need to try to get all of the signatures to amend a declaration if that's something that's really important to the community.
Okay, excellent.
Yeah.
Here's another one. Can a waiver of the restriction apply to an incurable violation, such as, and you talked about it in one of your slides, discharging fireworks, if it's restricted in the declaration?
So the waiver defense is difficult to bring up anyway, because you have to kind of prove that there is the nature and severity of the non-enforcement of the restriction is so large that the community has waived it, right? Or abandoned their ability to enforce. But it's also difficult with uncurable violations because it's hard to document those. And it's hard to enforce those if there's no way for the association to know that they're happening. So it would be difficult to defend with waiver on that, but I mean, it's not impossible, I don't think.
Okay.
Yeah.
Good question. How does the 4-year statute of limitations apply to maintenance and repair issues?
So the 4-year statute of limitations applies to enforcement of the governing documents, period, right? So if the association has not seen that there is a maintenance issue for 4 full years, then they cannot enforce that by lawsuit. Now they can send letters and they can perhaps reach out to the homeowner and try to get that violation corrected. But I'll tell you that the homeowner will say, well, that was there before I even got here, or, it's been there like that forever, or they don't have the money to pay for it or something like that. So it's difficult, which is why inspections are important. And
Mhm.
also, we talked about communication earlier. I would advise homeowners, other homeowners, that if they see something that they need to tell the association too, not like they're being snitches or anything, but if they see a violation and something that the community or that the inspector doesn't see, then they need to report it so that the association can do its job and enforce the restriction.
Okay. And we know the topic of Airbnb and vacation rentals, et cetera, is very relevant and prevalent today with our association. So this one is, should the owners running a VRBO be required to show some sort of liability insurance to the POA if in the event a renter is injured on the POA property?
Yes. Okay. So first of all, if the association allows Airbnb or VRBO, because that's a big thing, right? Most of the time they
Mhm.
don't allow it. There is some sort of limitation on the term of the rental.
Right.
But if they allow it, I don't mind having some sort of like information sheet for the homeowner they have to fill it out, that provides like their contact information so you can reach out to them directly if there's like a large party or something going on, and requires them to have insurance or something like that, so that in the event that something happens, like God forbid someone drowns in the pool or the river or something like that, then they have the ability to have that owner's insurance, and not just the association's insurance, not just the insurance that's provided by Airbnb, but the homeowner should have it too. I think that's a really good idea. I don't see why. And I would actually, if you're going to allow Airbnbs, I 100% will put that in the restrictions or policy or something like that too.
Wow. Yeah, that could get really messy, just thinking about
Absolutely.
liability.
Absolutely.
And then, there's one last one that has come in, and I think it's kind of related to short-term rental, but the question is, are there any Texas laws that allow current HOA homeowners to be grandfathered as their community implements short-term rental restrictions?
So unfortunately, if the declaration gets amended to prohibit short-term rentals, that is effective from the day that it gets recorded in the real property records, and it is effective to every property that's under the jurisdiction of the community. So there would not be any grandfathering in of homeowners who were previously doing short-term rentals, and now they have this amendment. There's actually a case that we just handled just like this, where the community previously allowed short-term rentals, but then they went through the process of amending the declaration. And so far, the court has held, and this is after appeals by the homeowner, that because that amendment was put in place, regardless as to whether or not this homeowner purchased the property specifically to have Airbnbs or VRBOs, that they are not allowed anymore as of the date of that amendment. Again, because the amendment of a declaration is actually the most important. That's the thing that you do that can stop everything, right?
Right.
So they wouldn't grandfather it in, because then that would open them up for non-uniform enforcement, right? It would be arbitrary and capricious if they did that. So probably not is the answer.
So unfortunately, like you said, the documents and the amendments override any type of grandfathering type of mechanism that may exist. It's usually not that case.
Correct.
Okay.
Correct.
Well, it's 12 o'clock on the dot, 1
Okay.
o'clock, I'm sorry, 11 o'clock your time, 12 o'clock Florida time. But this has been wonderful, Noelle. Really, really appreciate this time. It's really great information for all of us and community management and for the homeowners and board members. So we thank you all for participating. And Noelle, I'm sure that this will be the first of many more to come.
Yeah, I can't wait. And I thank you guys so much for having me today. I really had a great time.
Outstanding. We'll talk soon. Thank you,
All
everybody.
right. Thank you. Bye.
Bye-bye.